joined us today for our latest practice note webinar, which deals with 4 of our practice notes. I will be your moderator for this webinar. My name is Wally Main, and I'm a civil engineer occupying the position of Contractual Affairs Manager at CESA. After this webinar, we'll be holding 2 more CESA best practice webinars this year on the 27th of September and the 8th of November. And you're kindly requested to bear these dates in mind. We would like to take this opportunity to bring to your attention the Business of Consulting Engineering program, the BCE, which is an additional CESA resource available to you. The BCE is the flagship of the CESA School of Consulting Engineering and encompasses much of the detail and principles of the CESA practice notes. It is highly recommended that any engineers wishing to advance their careers in the consulting engineering sector should consider registering for this program. For details of the program and the many training courses offered by the School of Consulting Engineering, kindly click on the training heading on the CESA website, which, as you probably know, is www.cesa.co.za. I'd also like to inform you that the webinar is being recorded and that the presentations will be available after the webinar on the CESA website by clicking on the headings Guidelines and then Presentations. To access the recording of the webinar, simply go to the CESA website, click on the YouTube icon, and scroll through the recordings. Before we get started, I'd like to outline some of the house rules for our delegates, for you, our viewers. On the taskbar at the bottom of the screen, you'll see the chat and the Q&A icons. Please use the chat for any comments you may have and the Q&A for any questions you'd like to ask. And if possible, kindly indicate which of the panelists you would like to answer your questions. And the Q&A session will take place at the end of the webinar. To unpack today's topics, we are unfortunate to have 3 knowledgeable panelists joining us, for which we thank them greatly. They will each deliver their presentations, and only at the end of the webinar will there be a separate question and answer session covering all the presentations. Thereafter, the proceedings will close with some closing remarks. And of course, I'd like to remind the panelists to please keep to their time allocations as per the program. The first panelist we have is Dave Clark, who will give an overview of the CESA Practice Note 27, which deals with the client consulting engineering relationship. Dave is a professional engineer and also an active member of the CESA Supply Chain Management Committee. He is a civil engineer with extensive experience and was the chairperson of the CESA Eastern Cape branch in East London for many years. Dave was greatly involved in the recent development of the CESA practice notes, and he serves on the CESA practice notes subcommittee. I'd like to hand over to Dave at this point. So it's over to you, Dave.
Thank you, Wally. Today I'm going to talk about client consulting engineer relationships. I'm just going to try and share the screen with you. Hang on a sec. Right, okay, so some of you might wonder what gives me the right to talk to you about client consulting engineer relationships. When I was running the East London office of GIB, we were very successful, and people often ask me why we were so successful. And I said luck. It wasn't really luck. It was to do with our fantastic relationships with our clients. So today we're going to talk about CESA Practice Note 42, which describes the process of implementing complex multidisciplinary projects. This best practice webinar puts forward tips and ideas on how to interact with your clients on such a project. Remember, without clients, doing engineering work is just a hobby. Engineers are problem solvers, and clients always have a problem to solve. So we need to have clients. And therefore, if we're having clients, we need to have a contract. So there are several kinds of contract that we can engage with our client as PROXA, CRDB, FIDIC, NEC, and the like. To these clients, we have to provide absolute care. We must act in fairness and impartiality. And I think here the GCC and FIDIC differ slightly in that FIDIC says you act for the client, whereas GCC says you act for both parties. Determine very carefully what one is prepared to do at risk. Do not move ahead of yourself in the various stages in terms of deliverables. One instance I have in mind is that I was an RE on the airport township in East London. And I came into the office and I saw beautiful drawings of a road. And I said, what road is that? And they said, no, it's the road to your township. And it was a beautiful drawings, long sections of cuts and fills. And I said, have you done a geotech? And they said, no. So I said, I'm out there, I will go and do a geotech. And we did that, dug down, found the rock, then plotted on the long sections and worked out that the client's budget was only sufficient to dig out the rock. So we had to do the entire design again, going from 4 lanes to steepen up the cut and fill slopes. So just be careful about moving ahead in deliverables before you actually know what you're doing. Clients should ideally have the following: a project with a clearly defined scope, budget, timeframes, and most importantly, a willingness to pay. Without a signed contract, you're at risk. Your contract should include the following as a minimum: terms of agreement, a description of the project, scope of work, scope of service, financial terms, timeframes. And this last one is sometimes missing, but it's actually an important legal requirement to have timeframes. The fees can take several forms: lump sum, percentage-based, hourly-based, and CESA has a practice note number 45, which describes each of these in detail. And if you're unsure, then you must go onto this website and look at that practice note. Then always claim for additional services as defined in the contract. And these could include dispute resolution, time overrun due to contractors' late or poor performance, and that's a very common thing these days. Anything not defined in the project brief, scope of works, and scope of services. If you don't ask for more money, you won't get it. And all these years when I've needed more budget on a project, I've only once been turned down. So don't be afraid to ask. Traditionally, engineers like to be regarded as the trusted advisor. This trust has been much more difficult to attain in recent years because now we are tendering for work. In recent years, the construction industry has been beset with many issues: loss of experience and skills, turnover of staff in client bodies. Often the client is on a 5-year or 3-year term, and with that comes the loss of institutional knowledge. There's always a shortage of budget and corruption. Whenever a project is running into trouble, I always look to see, is there corruption at the heart of the problem? It's no longer enough to be the trusted advisor. One must now strive to be the trusted partner. So how does we build up this trust? When I was quite new in the consulting field, my boss came down from Durban and said, we're going to see our clients tomorrow. We leave at 5. I said, we haven't made no appointments. He said, get in the car and off we go. And we went to Queenstown, Barclays, Mthatha, Butterworth, and every place we got to, the client was there and available to see us and happy to see us. So that taught me that going to the client is probably the best thing you can do. And I used to load up all my engineers, 4 or 5 of them in in my Fortuna, and off we would go. And the client would be surprised. Oh, you've come in strengths. I wanted to show them we have real people doing the job, not just a post box. So that's how you must build up trust. But before even thinking about reports, designs, drawings, and procurement documents, the engineer must put on his procurement hat. The engineers are very keen to just plow into design. So there are the 10 project management principles, the PMBOK, and I'm going to go through them one by one. Project management functions should always be at the back of your mind when drafting up a professional services contract between yourselves and the client. First one, integration. Who's going to make the decision? Who are the stakeholders? Who will manage the JV partners and co-consultants and sub-consultants? Make sure whoever you have on your team has got the delegated authority. Scope. Identify and agree on the scope. Manage the implications of scope creep. Scope creep has got a lot of time and money implications, and if you manage it well, it's the easiest way to generate new business. But if you manage it badly, you're going to lose money. Time. Be honest. Be realistic. Don't plan to fail. Often we'd say, okay, we'll do the prelim design in 3 months, the detailed design in 3 months, procurement in 1 month, 7 months, and we tell the client that. But actually, you must build in float. Otherwise, you're planning to fail. Don't go in with over-optimistic timeframes. Plan the cash flow. Invoice early and monthly. Test the system. Make sure that there's a mechanism to pay you. Qualify your cost estimates. What I find is that engineers don't know the market forces. So you don't know if the contractor has got plant standing or he wants to keep his workforce busy. I had one occasion where an engineer came to me and said, what do we do about this late tender? It's exactly on the budget. I said, throw it in the bin. Because engineers' estimate to me are just a guess. So you don't know what the market forces are. Then update your budgets regularly. Clients don't like to get surprises. In terms of quality, define up front what's fit for purpose. Actively try and manage the procurement process. And thoroughly review all your deliverables. So often I see cut and paste errors. It's very embarrassing. And then the client sees the wrong municipality's name in his document and he thinks, what am I paying for? I want value for money. So take the trouble to review everything thoroughly. Human resources, ensure you have an engaged project manager. And that's not only in your team, but in your client's team. So try to make sure that the right people on the team so you can meet your deliverables. Mentor and monitor the junior staff. In terms of communication, write letters. Do not rely entirely on emails, messages, WhatsApp, Teams, and Zoom. Face-to-face improves communication and is far more likely to achieve results. Remote workers are often not effective, and you need to ask yourself, are you one of those? Pick up the phone. It solves many communication problems. I've had engineers arguing with land surveyors over the phone, and I happen to know the land surveyor. I called him into the office and sat them down in the same office for half an hour, and they walked out best of friends. They've been talking past each other. So take the trouble to communicate properly. Pick up the phone. Go and see the people. Take accurate and timeless minutes. Don't wait until 3 weeks have gone past before you do the minutes, because it's going to be a mess. It's an advantage to be the secretariat for your client and make that offer. In terms of risk, identify, manage, and mitigate risks and decide what risks you will accept. Ensure that a particular risk rests with those who are in the best position to manage it. And remember, mistakes never cancel each other out. They just double up. In terms of procurement, make sure you've got a signed contract with your client. Make sure you have contracts with your JV partners, co- and subcontractors. Steer the procurement of contractors to ensure that those who are appointed are capable of completing the works. Too often nowadays, we have contractors who have got very little money and they are appointed, and there is no chance of success. So get involved. Look carefully at the logistics of obtaining the materials you specify. It's another issue about cut and paste, that you pasting, specifying stuff that is no longer made. That's embarrassing when the client has to pay extra. Stakeholder management. Manage your client and the community you are benefiting. Be aware and ready for the interference of entrepreneurs, construction mafia, and business fora. I was out at 7 o'clock last night negotiating with construction mafia who were holding our contract to ransom. Push strongly to do the following upfront: geotechnical investigations, way leaves and servitudes, land surveying, and environmental authorizations. Clients are often reluctant to put money up for these things, but they are vital. For example, in a MIG project, you have to do a preliminary design, and the preliminary design needs an environmental authorization, which will specify that you need 3 preliminary designs. And you can't do any of those without geotechnical investigations, way leaves and servitudes, and land surveying. So push very strongly for these. They're vital. Be aware of the following: clients who are after your professional indemnity, and that is more real than you realize. Ensure that you get instructions only from those who have the delegated authority. Poor designs and documentation will lead to disputes, and a claim against your PI might follow. Keep careful detailed records, as these may be required in disputes or will be required in disputes, such as adjudication. And remember, a happy client is the key to return business. Thank you.
Thank you, Dave, for sticking to your time so well, and for so ably presenting on this topic and explaining the importance and nuances of having a good relationship with your client and the stepping stones to achieving this good relationship. And as previously mentioned, the presentations will shortly, or your presentation will shortly be available on the CESA website under guidelines / presentations. And just to note that CESA tries hard to empower its members with useful information through its practice notes and through webinars such as this one. Now move on to the second panelist, who is Wayne Hunt, who will address us this afternoon on CESA Practice Note 97, which deals with the conflict of interest for CESA members. He will also discuss Practice Note 21, which deals with payment certificates. Wayne is a professional engineer and an active member of the CESA Quality, Risk and Sustainability Management Committee. He is a senior civil engineer currently practicing with CESA member firm Knight Pisold and serves on the CESA Practice Note Subcommittee. And at this point, I'd like to hand over to Wayne. So it's over to you, Wayne. Thank you.
Thanks, Wally. It's a privilege for me to talk about these 2 practice notes today, the conflict of interest and payment certificates. So yeah, just to highlight the outline of my presentation. So Practice Note 97 deals with conflicts of interest where member firms are operating as investors or contractors. And then I'll go into Practice Note 21, which deals with payment certificates, which has also got some elements of conflicts of interest. And I'll share some of my experiences that I've had there. Okay, so practice note 97 is actually quite a short practice note. There was a question that was asked of CESA. And so for the informational benefit of the members, CESA wishes to share its recent response to this question regarding conflicts of interest where member firms are operating as investors or contractors as outlined below. So the CESA constitution clearly talks about a member not being permitted to be involved in both consultant and contractor roles on the same project, unless, for example, it is in an EPC process. I mean, one can imagine that if you were a client, you wouldn't want to have a consultant who is conflicted in such a way. So an EPC contract, just to clarify, just to give the full picture, engineering, procurement, and construction contract means the contract arrangement where the EPC contractor carries out the detailed engineering design of a project, procures all the equipment and materials necessary, and then constructs to deliver a functioning facility or asset to their client, which is also called turnkey. So the idea is that once the developer takes occupation of his asset that he's acquired, he literally just has to turn a key and walk in, and he's got access to his asset. That's where the term turnkey. There are other asset terms that are used. I'm sure you'll know some of them. Okay, so conflict of interest where member involvement is in an EPC contract. So CESA cannot prevent a consulting company from providing services in an EPC contract if the risk and liability is then managed as an integral component of the delivery by a consultant and contractor, both from the same company. So if it is managed and there are checks and balances to make sure that there aren't things that go wrong, then it can happen. Where you've got member involvement in a non-EPC contract, in the case where it is not an EPC, but a separate process where the consultant is required to act on behalf of the client, they cannot do supervision over a sister company doing construction, as that would constitute a conflict of interest. So members financing projects. Some members use the model of financing projects, but it is uncertain as to how they get involved in construction, unless, of course, it is some sort of EPC process linked to a PPP, a public-private partnership. And in this case, they would carry full liability, so there's no conflict. So I think that clarifies the question that was raised. I think the question coming out of this, the key question regarding conflicts of interest to remember is that it's considered whether the consultant is acting as part of a team that assumes full liability or whether he's acting on behalf of an external client, where there certainly would be a conflict of interest. So you can't be on both sides of the fence. Okay, so I think that it's quite a short practice note, but a very important one at that. So now moving on to payment certificates. In the construction stage, a payment certificate is used to certify the progressive value of a completed construction work every month. So generally, a client is only obligated to pay a contractor once all the work is finished. Same as if you went into a shopping mall and you bought an apple. You would buy the apple and pay for it. So the client's only obligated to pay for it once. This is the nature with infrastructure projects, that they have a long lifespan and there is a finance element to it. And so in order to avoid additional financing costs and admin, and to help the contractor with his cash flow, normally the clients are government entities which have got finances to actually carry the project. They then make payment to a contractor once a month. It's generally once a month, but this will be defined in the contract. It may be every 2 weeks, or it may be every second month. It just depends on what the contract says. So the payment certificate is governed by the construction contract. There are a number of places where payment certificates are included, but today, just for illustrative purposes, and what's contained in the practice note is FIDIC 2017 Red Book and the CESA GCC 2015. So the definition or description of a payment certificate. So in the FIDIC Red Book, payment certificate means a payment certificate issued by the engineer under clause 14, contract price and payment. And then in GCC, the employer's agent shall, by signed payment certificates issued to the employer and the contractor, certify the amount he considers to be due to the contractor. So it's a document which is signed by the consulting engineer. It is then given to the client and employer. That is determination of the work that's been done, the value of the work, and then that becomes payable by the client to the contractor. So the types of payment certificate that you get in GCC, we've got an interim payment certificate. So each month you'll have an interim payment certificate. Once the work has been completed, you'll have a completion payment certificate. There will be retention monies that will be retained during the defects liability period, which is normally carries on, say, for a year, for example, after the project has been completed. And if there are no defects, or the defects that do arise are repaired by the contractor, then the final payment certificate will release that retention to the contractor. And there may be some work which is done, which is payable during the defects liability period. In the Red Book, there's also an advance payment certificate. So this might be very large projects. I've dealt with that on one of my projects where there's an advance payment made to the contractor. And then the advance payment is then deducted periodically in subsequent payment certificates until it goes down to zero as the work progresses. So the client's actually paying for work done. So there will be interim payment certificates and then final payment certificates. Okay, so just to go through the components of a payment certificate, there are 4 slides on this. So a payment certificate usually does not contain any separate attachments. So on many of the projects that I've worked on, we will do calculation of quantities and verification of quantities, quality assurance. So those will stay in the office. They don't form part of the payment certificate, but they are a necessary backup in the event that they are needed for a dispute or otherwise. So they must contain certain minimum information. So whether it's interim, completion, or final, obviously the certificate number, the measurement date. Often what we do is we measure on the 25th of the month. Clients have budget requirements to make payments or to recognize that a payment is due by the end of the month. So to do it periodically makes sense. So we would say measure by the 20th of the month. The engineer approves it and submits it by around the 25th. And then the client can then process it before the end of the month. It must contain the date that the contractor's statement was received, the contract number, title, and then names and addresses of the various parties, the contract sum, commencement date, and the due completion date. Then also estimated value of the permanent works, amount for temporary works, variations, claims, amounts related to dispute resolution, and other additional amounts and adjustments. Plant and materials, amount of all previous payment certificates, penalties, retention money, contingencies, arithmetical corrections to previous payment certificates. That does occur. The interim payment certificates are interim, and it does happen that you pick up that an error was made on a previous payment certificate. So this can be adjusted. And then VAT. Then we've got the declaration of certification, where the engineer declares that this is an accurate estimated value of the works. Often you have to estimate some of the quantities, which is fine as long as it's an interim. When you get to the final certificate, then you will need to make sure that the quantities are not entirely estimated. And then a signature block and a place for the employer's agent to sign. There may also be supplements to the interim payment certificate, where work has been done by subcontractors, or there are quality documents that are important to show the client as verification for that payment certificate. So the authority of a consulting engineer to sign a payment certificate. So a consulting engineer derives the authority. He's the employer's agent. The employer is entrusting him to be his eyes and ears on the site to make sure that the work is being done and it's been done according to the specifications and as per the contract. So there's a construction contract which exists between the employer and the contractor, which the consulting engineer is administering. There's also a professional services agreement which exists between the employer or the client and the consulting engineer. And this will define the terms of how the payment certificate must be compiled. So that's very important because there might only be certain aspects of the payment certificate that are delegated to the consultant. In certain cases, that has been the case, but your professional services agreement will stipulate that. So the construction contract stipulates that the consulting engineer fulfills the role of the employer's agent, engineer, project manager, or principal agent, or as another role player, and is normally specified to be a registered professional in the highest category of registration with one of the 6 statutory councils under the Council for the Built Environment Act. So the standard usually adopted is the CESA guideline scope of services. There is a pro forma payment certificate, which is on the GCC website. And if you just download the practice note, it's got the link to that pro forma. And then two consultants on site. Project. There were 2 consultants in our project, which had the road which was passing underneath the other road. There was also an interchange with the 2. I think it's just to highlight the extent. So we were responsible, obviously, for being the consultant for our part of the project, and the other consultant was responsible for his road, which was going over ours. Yeah, so it is not that plain and simple when it comes to insurances and liability and site safety and those aspects, because the contractor doesn't separate. Well, in that case, it was one site to him. So, you know, if somebody walks from the one on our road, walks underneath the bridge of the other road, you know, where does the battery limits of each of the projects end? But yeah, that basically the best way to do it is to define the sites, the battery limits, where the one job starts and the other one ends, and manage it as best as possible. Okay, then I'll just talk quickly about payment certificates and in relation to conflicts of interest. So proprietary products. So where there are proprietary products and the contractor, for example, is using products of which the consulting engineer has an interest, that would be a conflict. And there are ways to manage it. The client can get an independent party to to sign off certain parts which relate to those products. Then we've got the sub-consulting to a subcontractor. We had a situation on one of our projects, a road project, where we had a drilling contractor. The drilling contractor does drills cores. The core logging of the cores is done by a consultant. So we were not able to bid for that work, as it would be a conflict, because once the drilling contractor submits his payment certificate to yourself, you then are certifying work which you yourself have done. So one can see that there is a conflict there. And then also having an interest in service providers such as laboratories. So the history of that in South Africa many years ago, 30 years ago, in order to get roads projects, you had to have a laboratory. Some companies were didn't have enough workload to sustain a laboratory on their own, so they set up laboratories where different consultants would have a share in that. So things have changed in that, and that now it does become a conflict, but it can be managed so that the procurement of those laboratories is done by another consultant or by the client themselves. Okay, then we'll just discuss quickly about the requirements for a liquid document. The signed payment certificate is usually attached to an invoice and a statement from the contractor, which is then submitted to the client or employer as a liquid document. So in other words, the payment certificate is a component of the liquid document and not the other way around. So just to clarify, a liquid document is when the one party is obligated to pay the other party. So that obligation has arisen at the time that the consulting engineer signs that payment certificate. So often consulting engineers don't consider what happens if a client fails to pay, or if there's refusal or interference by the client. So refusal or interference by, sorry, the Y is missing there, by the client or employer is unlawful. Once the responsibility to sign that payment certificate is given to the consultant, the client is not allowed to get involved in that process. So there was a court case that came up with this, and I do apologize for this slide. It has a lot of text on it, but I think it is very important. And this is my last slide, so thanks. So in this high-profile litigation case, the Supreme Court ordered the MEC, the Department of Human Settlements of the Eastern Cape, to pay the contractor Avenge Brinica an amount of 3 million rand duly certified for payment under the contract, but which was unlawfully withheld, together with interest which accumulated over more than 3 years, plus the cost of the court case. So an extract from the judgment, which is key to understanding how important payment certificates are. The authority of the principal agent to authorize payment and bind its principal was not in dispute. The construction agreement provided that the defendant as employer could not dispute or refuse to honor the obligation to pay an interim certificate issued by its principal agent. That obligation resulting from a payment certificate created a separate obligation and cause of action independent of the contract. And then the defendant is to pay the plaintiff the sum of 3 million together with interest calculated at the legal rate of interest from the 13th of November 2014 to date of payment, which was after 2018. So you can see how long these court cases can go on for. Okay, I thank you very much. With that, I'll hand you back to Wally.
Thank you very much, Wayne, firstly for sticking to time, and secondly for an excellent presentation, which I think will greatly assist members in understanding the principles of the conflict of interest as advocated by CESA, as well as understanding the intricacies of payment certificates and taking note of your practical steps or guidelines. Just to remind everyone that the presentations and the recording of the webinar will be available on the CESA website. Okay. Moving on, the final presentation or the final panelist will be Francis Gibbons, who will speak on CESA Practice Note 98, which deals with assessing risks in penalty clauses in the consultancy agreement. Francis is a professional engineer and an active member of the CESA Supply Chain Management Committee. He is a retired civil engineer with extensive experience and was greatly involved in the recent revision or updating of the CESA practice notes. Francis is the chairperson of the CESA practice notes subcommittee. And so at this point, I'd like to hand over to Francis. So it's over to you, Francis. Francis, you're still on mute. So sorry.
Apologies. Thank you, Wally, and good afternoon, everyone. It's a privilege to present to you today on the topic of Practice Note 98, which covers the assessment of risk in penalty clauses in consultancy contracts. So the purpose of the project practice note is to bring the matter of penalties in consultancy agreements to the attention of members and provide a risk assessment methodology to quantify the associated risks at tender stage. So it's about, as it says, it's about penalty clauses in consulting engineering agreements, and we won't go into applying penalties in construction contracts, which I'm sure most of you will find to be a more comfortable space. So the use of penalty clauses in both private and government consultancy agreements is quite common. It's unfortunately become a part of modern business practice. The agreements are much more commercial. The supply chain management officials who are running the agreements are focused on the commercial aspects as well as just the technical. So consulting engineers need to take note of these as part of their risk assessment for a particular tender and make appropriate allowances in their pricing if deemed necessary. It's not something you want to skim over if there's penalty clauses in the agreement that you will be signing if you win the tender. There are a few of the big, shall I say, big agreements that do not have standard penalty clauses. That's the CESA Model Professional Service Agreement that was updated and published last year in 2021. Also the FIDIC Client Consultant Model Services Agreement, the White Book of 2017, and the PROXA Client Consultant Professional Services Agreement of 2012. None of these have penalty clauses in them. However, that doesn't mean that there's not a penalty clause that could be introduced by the client under the particular conditions. Especially with the PROXA agreement, we found that often in the case of, for example, property developers, they introduce quite stringent penalty clauses in the particular conditions. So I'll just go through a few of the standard agreements that have standard penalty clauses in them or have penalty clauses in them. So under the CIDB professional services contract, the employer may levy a penalty for every day or part thereof that elapses between the end of the period specified for performance and the actual date of completion. And then the thing about the CIDB, which one should be aware of and should look out for, is that the rate per day and the maximum amount of the penalty should be stated in the contract data. Quite often the amount of the penalty as a rate per day is specified, but not the maximum amount. So a typical value for the penalty in recent tenders that I've seen is 2,000 Rand per day, something like that. and often it's the maximum value stipulated is 10% of the contract value. Then treasury conditions of contract, national treasury conditions of contract rather, are quite commonly used by various government departments. And under clause 22, penalties, it's specified that if the supplier fails to deliver any or all of the goods or perform the services, because these conditions of contract are used for the supply of goods as well as services. So if they fail to do that within the period specified in the contract, the purchaser shall, note the shall there, deduct a penalty calculated on the delivered price of the unperformed services using the current prime interest rate calculated for each day of the delay until actual delivery or performance. So I've just worked out an example of what this has. Say you had a 4 million rand fee on a project and you were late with the design development stage, so the detailed design stage, and that is worth 25% of the fee. So it's about R1 million for that stage. So say you late by 2 weeks, you'd calculate the penalty at R1 million times 9%, the current prime interest rate divided by 365, so it would be 247 Rand a day. And for your 2-week period, the amount would be 3,500. So these conditions are not too stringent, unless, of course, you have a much larger project, but then still your penalty will be small in terms of the overall amount. The SANMIL conditions of contract have penalties for a number of aspects: for failure to meet milestone dates, failure to capture the structures, inventory and condition updates, failure to disclose subcontractors, and failure to meet the specified target for work for targeted enterprises. So again, common values of the penalty for failure to meet a milestone date is around 2,000 Rand a day, up to a maximum of 10% of the contract sum. And then they got one tender I looked at for failing to capture the structures inventory. It's 5,000 Rand per structure, up to a maximum of 50,000. Failure to disclose subcontractors can be 10% of the contract value, of the subcontract value. And failure to meet the specified target of work for targeted enterprises, 30% of the value by which the cumulative value of payments to targeted enterprises fails to meet the specified percentage. So there's a number of things that can trap you here and cost you money. Okay. Then the NEC professional services contract, it doesn't have a specific clause regarding penalties, but there are these options, and option X7 can be adopted, in which case the nature and extent of the penalty would need to be defined by the client in the request for proposals. So it's also quite common, if there is an option X7, to also have an option X6 in the NEC, which specifies sectional completion. So it'll specify key dates for sections of the work, and penalties can be applied to delayed performance in each of these sections. An example from one of the clients, state-owned enterprises that uses NEC3 is AXA. And there, again, it's the amount of about 2,000 Rand per day and an upper limit of 10% of the contract value. So these can build up quite substantial amounts. Okay, so is there any any legal act that protects you from in respect of penalties? And there is the Conventional Penalties Act, Act number 15 of 1962, so it's been in existence for quite some time. And under section 2, it's only a one-page act, so it's quite easy to read. Under section 2, the client is not entitled to recover both penalties and damages, so they can't specify penalties in the contract and then say, oh no, we suffered another 100,000 Rand damages, you must pay that as well. Also, the client is not entitled to recover damages in lieu of penalties, except where the contract expressly so provides. So if the client can't decide, oh no, I've suffered much heavier damages than the penalties I've got in the contract, so I'm going to sue you for damages, they can't do that. Then under section 2.2, a person who is obliged to accept defective or non-timeous performance cannot recover a penalty unless the penalty was expressly stipulated for that defect or delay. In other words, if there isn't a penalty clause, you can't just deduct penalties, and your only option would be to sue for damages. So you would have to go to court or declare a dispute and then go through the whole dispute resolution process. And then under section 3, if upon hearing of a claim for a penalty, it appears to the court that the prejudice suffered by the client is out of proportion to the penalty, the court may reduce the penalty to the extent it considers equitable, considering not only the client's interest, but every other rightful interest which may be affected by the act or omission in question. So there are cases where perhaps the penalty exceeds the damages suffered by the client and any other parties, and in which case you could go to court. But I mean, it'll be unusual that you would want to face the costs of litigation to get your penalty reduced. So it's much better to plan for not getting penalties. Okay, that brings me on to the next section of this practice note, which is about the risk assessment. So consulting engineers are encouraged to undertake a risk assessment as part of their preparation for a particular tender. Where a penalty clause is included in the contract conditions, this would be one of the risk areas considered in the analysis. And CESA has the RMEG, the Risk Management Implementation Guideline, available on the CESA website, which has a complete handling of risk management in a consulting engineering practice. So it's really good, a really good document, and it's encouraged that you look at that if you haven't seen it already. It's quite a substantial document covering both the business aspects, the risk to the business, as well as the risks in projects. So what is the risk management process? Well, first of all, the penalties for delayed completion are often tied to key milestone dates as well as to the services completion date. And the recommended process for assessing the risk of incurring penalties at proposal stage would then be as follows. It would be to identify the risk and mitigate the risk and quantify the residual risk. Now that's what Dave was saying in his presentation about managing the risk under the project management fundamentals. And so how would you identify the risk of late completion? You would prepare a critical path schedule showing all the tasks to be completed in the project, and to achieve each key deliverable, identifying critical path through each of the key deliverables and all the key milestone dates. So you'll have obviously you'll have a good work breakdown structure, and then prepare a critical path schedule showing where your critical path is. Then you need to allocate the resources to each of the tasks and the effort required from each team member or resource to complete the task. Check the period available to complete the deliverable is sufficient considering the hours required and that some float is available. Again, reinforcing what Dave was saying, you need to build float into these things. One is always keen to offer the client the shortest possible period for completion, and thinking then that you're going to make the most money. But it's good to be put a real rational hat on when you do that and think about how much float you need. So now you've got your critical path program, you've allocated your resources. Now you want to consider the probability that some internal delay could cause delayed completion of each of the deliverables. So this requires careful consideration of the assumptions made in compiling the critical path program. For example, the project delay might be caused by team members concerned being overcommitted or sub-consultants for which the consultant is responsible not delivering on time. Often there's a significant period between the date of submission of a proposal and the award date. And this can lead to team members no longer being available for the project or being available a lot less, have a lot less time available to do the project. And so that would obviously lead to perhaps either putting other people onto the project or delays taking longer than you expected. So the second step then is to mitigate the risk. We've identified that there's a risk of delay because the contract is awarded 9 months, a year later than we expected, and everyone's now busy. And so how can you mitigate that risk? So the obvious thing is to increase the float in the program by allocated additional resourcing. You can also mitigate some of the risk, or transferring the risk to sub-consultants who are on the critical path and make them responsible for penalty if they are the cause of the delay. That's also fraught with all kinds of disputes. But importantly, you want to make sure you've got the resources and you've got the float. So finally, you want to quantify the residual risk. And so now you've managed the risk. You've added people into your costing, into your work breakdown structure. You've perhaps increased their time by certain amounts or increased the float. But now what are you left with? So is there still a possibility that you're going to be late, that there's going to be a delay? And you might think, well, yeah, I suppose the worst case is that there's going to be a 10-day delay in the delivery of that particular deliverable, and let's use our commonly seen penalty of 2,000 Rand a day. So you've got a penalty of 20,000 Rand. Okay, that's not 100% certain that'll happen. You've got a probability, perhaps that'll only happen 20% of the time. So you then can get the expected monetary value of the risk, which is what you want to get to, which would be 20% of 20,000 or 4,000 Rand. So you've arrived at the expected monetary value. Now, we've said, okay, our business is at risk here for 4,000 Rand for penalties if we're late on this particular aspect. So the next step is to decide what you're going to do about that. You know, often you might think, well, I've determined that there's 4,000 Rand and I don't mind. And there's two options. You can either accept the risk and not increase the tender price for the services to allow for the risk. This will depend on the quantum of the expected monetary value of the risk in relation to the expected profit. So if 4,000 Rand is the expected monetary value of the risk, and you're expecting a profit of 50,000 Rand, then perhaps you're happy to carry that risk. So it depends on the value of the risk in relation to the expected profit, as well as the risk appetite of the firm. Or secondly, you might build a contingency into the tender price to cover all or part of the expected monetary value of the risk. That is, in the situations, for example, where the penalty is now perhaps a substantial, or the expected monetary value of the penalty is a substantial part of your profit. So you would rather increase your price than to provide for that. But whatever you choose, if you've gone through this process, you're in a much better position. You're in an informed position to make a decision on what you do. So it's something that should be looked at in details. Okay, and then this is my last slide. What are the other considerations? So an important consideration is that penalties are not covered by your PI insurance, so it comes straight out of your pocket. The second thing is during contract negotiations, you should try to have the maximum penalty stipulated in the agreement where this is not already done. So under the CIDB agreement, that requires that the maximum penalty is stated in the contract data. And if the client hasn't done it, you should negotiate something in that point, or if you raise it prior to tender's closing, perhaps they will then put in the whatever it is, a 10% limit on the contract data. Yeah, sorry, on the penalty in the contract data. Then just coming back to that provision in the Penalties Act, if the quantum of the penalty is out of balance with the likely damages to be suffered by the client as a result of the delay, the only recourse to the consultant will be to go to court. And now this is expensive, as I mentioned before, and it's very seldom worth the effort and cost involved. So it's recommended that a request is made at tender stage to have the penalty adjusted via an addendum to the request for proposals at that time. So, you know, if you put in a request and can show that the penalty in the RFP is out of balance with the likely damage to be suffered by the client, then they might consider that reducing it. And I suppose you could even appeal to Mr. Main of CESA to write to the client as well. And that brings me to the end of this presentation. Thank you very much. I hope you found it informative, and over to you, Wally.
Thank you very much, Francis, for your very interesting and I must say comprehensive presentation. It's provided useful guidelines for our members on dealing with the risks and penalty clauses in their formal agreements with clients and of course the options available to them. At this stage in the proceedings, I'd like to pose the questions submitted by the delegates to the panelists for their response. We do have some time for questions, so we won't be skipping any of them. The first question, there were two short questions about CPD points. There's 2.2 CPD points for this webinar, and there was the other one about notes. So only the presentations will be available on the website, plus the recording. Unless, of course, the presenters wish to make the detailed notes available. But the first question is for Dave Clark. It's from Lemius Mashule. Sorry, I can't read my writing. Mashile. Writing letters has a challenge that the client delays in responding to the letters. How do you bridge this challenge? So obviously, if you write to a client and they just delay or they don't reply. Dave, would you answer that, please?
Okay, I did respond online, but it's a problem, and it's not an easy problem to solve. But one of the ways we do get around it is when you write a letter to the client, say, if you do not respond by X and X date, we'll deem that you have accepted our recommendation, or something to that effect. So you actually force a decision out of him without, if he doesn't respond, you just go ahead. That's how I deal with it.
Thank you very much, Dave. I think that's an excellent answer. Wayne, the next one is for you. It's from Tato Mkize. In the GCC, we cater for MOS or materials on site of 80%. What considerations are made to come up with this value?
So generally, when materials on site, so materials have been delivered to site, let's say, for example, you've got crushed stone, you've got a stockpile which has been delivered to the site. The contractor has to pay the quarry that he's purchased it from and delivered it to site. So he's incurred about 80% of the cost. It's an empirical figure that's been derived over many years. And the thinking is that he probably still has another 20% of costs to incur by taking, say, the crushed stone from that stockpile and placing it in its final position.
Okay.
So,
Yeah, so thank you, Wayne. I think that's an excellent. I have two more quick questions for you, so I'll just ask you them. Then from Chalmers Pagiwe, what do you mean by the contractor's statement? Re the date the contractor's statement was received. So I think it's just a point of clarity.
okay, yeah. So generally, it depends on the contract that you're dealing with. But on the projects that I've worked on, normally the contractor would measure his own quantities and he would deliver a statement to say, this is what I think the quantities are for this month. And then the engineer then has got 7 days or something like that to either agree or disagree with the quantities. So he's got that 7 days to check the quantities. And if he disagrees with it, he'll then determine his own quantities and then give that back to the contractor to say, I disagree with your quantities. This is what the quantities are that I'm willing to certify for payment this month. And then there are dispute mechanisms if the contractor disagrees with that. But the ultimate person who calculates the payment certificate is the engineer. But in practical terms, the contractor has got access to his man hours and production figures and all that. So that statement that he delivers to the engineer is the payment certificate, essentially.
Okay, thank you. Excellent answer. Just the last quick one. I think it was in relation to the principal agent. What do you mean by the highest category of registration? And that's from Nama Zonda.
So that would be in the respective body. It would be the category of person which has got the highest experience and qualifications. So yeah, so in X's terms, that would be an engineer as opposed to a technologist or a technician.
Okay, yeah, thank you. That's how I understood it as well. Then I think this one, maybe I can direct towards Dave. It's clients like Sanral appoint original design consultants and then construction supervision consultants. Would you recommend that strategy in future projects going forward? And the second question related, how does that build or maintain work relationships between employer and the consultants? So Dave,
okay, the first problem I have with a separate someone that didn't do the design is now doing the supervision is the question about split responsibility. So as soon as the supervising engineer issues a site instruction, he's effectively changing the design. So now whose design is it? So I don't like that idea. Also, you might find that the new supervising consultant might want to do a design review. So I don't think it's a good way to go, but it happens quite a lot nowadays on these 3-year term appointments, is that a consultant is only appointed for 3 years. He does his design and then his contract comes to an end. So now the client has got a design that he needs to have constructed. And there again, we have split responsibilities. Maybe Wayne or Francis can actually expand on it.
Good. Wayne, would you, or Francis? Do you want to add?
Yeah, I think I agree with Dave. I think the issue is the split responsibility. How does when there are changes required to the design during the construction, is obviously the supervising consultant can't do anything. He has to refer it back to the designer, the original design consultant, and that just introduces inefficiencies and additional costs. So the whole thing comes a bit less efficient. I think that's the point I wanted to make.
Okay, thank you very much. I think we'll move on to the next question, which is directed to Francis. Can a consultant be found to have breached his duty to perform with due skill, care, and diligence if there is a delay in a contracted completion date? And if so, is this something his PI insurance would respond to? In other words, pay damages resulting from delay claimed by client. And it's Andy McClarity who posed the question. His understanding is that PI insurance will not cover the contracted delay penalties. Francis?
Okay, that's a tough question, Andy. I mean, I think there's a number of complex aspects to it. So can a consultant be found to have breached his duty to perform with due skill, care, and diligence if there's a delay? So, you know, the client could, if they can show damages, they could then try to claim those from the consultant. I think that's the first point. So, and as long as there's, again, not a penalty clause in the contract, because as we saw under the Penalties Act, that if there are penalties, that is their only recourse. So let's assume there's no penalties in the contract, and there's a delay, and the client suffers damage as a result, and so they would have recourse to the consultant, and the method would be presumably to declare a dispute within the contract and allow that to run its course. Okay, so now I suppose the question really is about the PI insurance. Does that kick in? And you're right to say that the PI won't cover a delay penalty, but would it cover damages claimed by the client in the case that the consultant is late? That's a little bit more tricky, because I know of instances where, in an indirect way, the PI has stepped in and covered it. But I'm not, I'm not sure of the true legal position there. I'm not sure, Dave, whether you or Wayne want to comment.
No, I'm not sure I'm the right one to comment on that one.
Yeah. If I could just say but I'm not as expert as you presenters are, but certainly PI responds to claims based on negligence. So if a claim is initiated by the client, then it will be defended, at least by the PI company and the insurance company. But a penalty, I know that's pretty much excluded, because it's no risk that you've accepted, I think, as a contracting party, and they don't cover you for that. So moving on, we've still got a couple of questions. Next one, which is Lemius's second bite at the cherry. He says it's a question for Dave. In the interest of building client relationships, would you not recommend keeping communications more informal? This is a follow-up to your point about writing letters rather than relying on emails, etc. And that's from Helen Dunnell. Yeah. Dave?
I'm a firm believer that you write letters. I've never ever regretted writing a letter, but I've often regretted not writing a letter. So my answer is put it in writing.
Okay, thank you very much. Sorry, my screen moved, so the question I was addressing moved. I was talking about, I was supposed to ask Wayne, I think. It's from Lemius. These days, they ask whether you have any case against the client in tender documents. What are the risks on future work if you resort to court on disputes? Wayne, are you able to have a go?
Sure, yeah, I don't know. I think Yeah, I can see why the question is being asked, because you may have a very legitimate case, and just because you're now taking your client to court, they may exclude you from awarding you a tender. I don't think it's been dealt with in a fair way from what I've seen. But yeah, look, that's just my personal opinion. I don't proclaim to be an expert on this matter.
Can I come in there? I think the very last resort is to go to court. Much better to do an amicable settlement or go to mediation, adjudication, and really those are the routes to go. If you go to arbitration, it becomes very messy, and if you go to court, you might be there forever, and you will never get back the money that you want to claim. There are instances where people go to court, but they've got more money than sense quite often, and they're just fighting because they've got money and they want to win on principle. But I very seldom think it's worth going to court unless it's a really big matter, big money. You know, some of the construction companies do go that way. They've got the money, but consulting engineers, I don't think we have the money to actually go to court.
Yes.
That's my 2 cents worth.
Thank you very much for your practical answer, Dave, and thanks for your answer, Wayne. The questions are coming in thick and furious, so let's move on. This is from Mishak. Can a clause in one contract be incorporated in another form of contract? For instance, can an advance payment be incorporated in a GCC contract, given that SMEs generally have a low cash flow? If not, how does one deal with a lack of cash flow on the part of the SMME? Wayne, you spoke on the payment certificates. Would you be able to address that, or Dave?
Yeah, sure. Yeah. So any contract can be amended. So there are special or particular conditions to any contract, and parties can agree to anything. So as long as it's agreed up front, then by all means it can be included. So I've seen this quite a lot, and different clients have got different preferences regarding certain clauses and prefer to change them. Some private clients even have their own conditions of contract. So yeah, by all means it is possible.
Okay, thank you very much, Wayne. And I hope that answered your question, Mishak. I think it did. But another question here from Helen Dunnell, and it's directed to Francis. Are there any mechanisms in place to ensure timeliest response from the client? Not just in terms of EOT for the consultant, but more in the interests of progressing the project. For example, projects that remain in preliminary design phase for years on end. Francis? Thanks,
Wally. Thanks, Helen. Interesting question. So I think the key is to I think, well, there's two aspects to it. I mean, in terms of delayed completion, obviously you want to protect yourself, so you want to make sure that you record whenever the client takes longer than a reasonable time to respond to queries or approvals or whatever. So I think that's the first thing, so as you're going along, it comes back to what Dave is saying. You need to notify the client, hey, we're waiting a week now for your response. Hey, we're waiting 2 weeks for your response, so that it's all in writing and you can substantiate a claim for an extension of time. I think that's the easy part of the question. The second part of when you're talking about preliminary design phase dragging on for years on end, I'm not sure that I have an idea on how to handle that. It's obviously there are times when the client's budget is insufficient to continue with the project, or that to continue with the next phase, and that happens. unfortunately, there are clauses in the contract which allow you to terminate if nothing's happened. Because I mean, you can treat it like a suspension on the client has suspended the services by not progressing the project. But then your only way out is that you're going to terminate in the end. So it's not, perhaps that's not what you want to do.
Yeah.
Dave, you want to come in there as well?
No, I was thinking about it. I don't really have an answer on that. It's a common problem. I find nowadays that we get very little response from clients. Some of them have taken a year before we've got a response, and we're still waiting. So, and it might be preliminary design, it might be during construction, and it's really is a problem. I think if you have a problem at a certain level, you need to get above that level. So if you're not having any joy with your project manager, try and engage a senior, or even as has happened recently, we've gone to a minister to try and unblock a problem. Because the clients, they're very junior these days, and they're scared to make decisions because everyone is looking at them, and they're worried about a qualified audit or a query from the Auditor General or something, and they're very scared to make decisions. So sometimes try and go above their heads. I know it might rock a few boats, but that's what I do.
Okay. Thank you. Thanks very much for that answer, both of you. The last question I have, I think it's the last one, is from Werner Comrie. And I think, I'm not sure, you guys must decide. It seems to have the essence of penalties, but anyway. But it also talks about EPC, which is Wayne. So this is the question. In the EPC space, how much theory and practice is there in being the engineer as part of the contractors team in the space of penalties applied? So as consultants, our client is the contractor and not the end or ultimate client. Which form of contract is best applied, or is it just a negotiated process then? That's from Werner.
Okay, so perhaps I can kick off. Obviously, you want to have the best agreement in place that you can, and often it's to have a client consultant relationship with the contractor. So you don't use a subcontract form of agreement. You use a client consultant form of agreement, and then all your terms are sort of don't go beyond into the contract between the contractor and the ultimate client, the employer. So that's first prize, and then obviously you can have your own penalty clauses, etc. in them. The problem arises when you're in like a subcontract role and you are subject to the main contract. And then they will try and pass on to you their penalties and that sort of stuff, and that's quite difficult to mitigate against. So they might have much heavier penalties than you would. So again, I think it would be important in the subcontract to limit your penalties to something that's in line with your own contract value rather than in line with the main contract value. Thanks. Okay. Dave, anything to add?
Just maybe it's slightly off the point, but the laws of liquidation supersede the laws of the contract. And so quite often someone will persuade you, oh no, we'll pay you directly, we'll do this or we'll do that. But the laws of liquidation supersede the laws of the contract. So if things are starting to go sour, just be very careful.
Yeah. Thank you, Dave, for that wise word. Wayne, do you want to add or? Okay. I think he's frozen. But anyway, that was well answered. Thank you very much, Francis. I think it's a good time to end the questions and just carry on with our closing remarks. Thank you very much for answering those questions. So we've come to the end of the Q&A session, and I hope all the questions have been addressed. I would like to inform you, however, that you're welcome to email me at wally@cesa.co.za regarding any questions that you may still have or that were not answered during the webinar, and we will see that they are answered. So colleagues and friends of CESA, we have reached the end of the webinar, and I would like to thank the panelists for availing of their time and for sharing their knowledge and thoughts with us. And of course, I'd like to extend a big thank you to you, our delegates, for supporting CESA and attending this practice note webinar. Before we close our session, we would like to invite you, it's everybody, to submit any comments or suggestions you may have regarding our best practice or practice notes webinars with a view to improving them and making them more useful. You are welcome to suggest topics that you would like addressed at future webinars. And again, you may send me your comments and suggestions at wally@cesa.co.za. In closing, I'd like to kindly request delegates to complete the satisfaction survey that will pop up on your screen when you exit the webinar. The purpose of the survey is to provide us with your satisfaction ratings or feedback that will enable us to improve our future webinars. And this is just answering one of the questions. Delegates registered with EXA may claim 0.2 CPD points for attending this webinar as per our webinar attendance list. For ease of administration, CPD certificates will be sent to delegates upon their completion of the survey. And as a very last point, we'd like to ask members to regularly check their spam or junk folders for CESA correspondence in case it has ended up there. We'd also like to request that you whitelist the email addresses that CESA uses. And with that, thank you again for your attendance and participation. And I'd like to wish you a good day further. So it's goodbye.